contributions from the audience as well. So now I'd like to continue with our last speaker, Mr. Gönenç Gürkaynak. Mr. Gürkaynak is holding a faculty member position at Utrecht University Law School and also acting as partner at ELIG Gürkaynak Attorneys at Law. He will be delivering his speech on self-preferencing issues and the gatekeeper role in antitrust law. Mr. Gürkaynak, the floor is yours.
Thank you. I actually had a presentation, but I just decided not to use that. Basically, I think what is most important at this point is that we discuss the matter in a more fluid way. Maybe you might want to interrupt and ask questions, and I'm open to that kind of debate environment as well. Mainly, most importantly, what we should diagnose first is that certain disciplines have long established concepts that are grounded by undoubted principles. And as I was presenting to Thibault during my question to him, these principles of competition law have been created through decades, and they are accepted by legal institutions. It doesn't mean that these are written on stone, and clearly we can make changes in these, but we shouldn't do these changes with light and transient whimsical approaches. And when we do it, we need to make sure that everyone understands the same thing from that particular concept, which is a significant issue right now with the concept of self-preferencing, or with allegations that indicate self-preferencing. So these allegations have been put forward for the first time in 2010 by the European Commission. When they were looking into Google's shopping services, they ultimately resulted the investigation in an administrative monetary fine of somewhere around 2.4 billion euros in 2017. So the birth of the self-preferencing vocabulary is about 11 years ago, and the first official recognition of it is about 3-4 years ago. Why am I saying this? I'm saying this because we should all diagnose that we're discussing something very, very new. We have been hearing it, we have been reading about it, writing about it, some of us, but it's very new. Which also means that my criticism about this term being too fluid cannot mean that it should have never been created. I'm not trying to say that the antitrust enforcers and lawyers are not at liberty to come up with new terminology. What I am saying is they should be alarmed when this is happening, and they should make sure that there's some consistency into how this is being treated. When you want to define self-preferencing, you would say that this is a specific technique of leveraging a platform's market power, giving preferential treatment to one's own products or services when they're in competition with products and services provided by other entities using the same platform. So basically, you do have a platform and you are discriminating in your own favor by way of promoting your own products or services in one way or another. Digital platforms, therefore, not surprisingly, have been in the focal attention of self-preferencing discussions because they're in the business of creating and capturing value. They're in the business of creating and capturing value, so the counterfactual analysis has also been extremely important and missing from a lot of these cases. This is something Thibault has also alluded to, and I was intending to underline the same phenomena as well. So when you're taking a snapshot of a marketplace and you're looking into a current practice at that particular point in time, without regard to what would have happened had this not been the methodology, would this product have been produced if they knew that I was going to come up with this kind of enforcement? These kinds of questions are all counterfactual questions. And digital platforms, particularly search engines, have been defined as internet intermediaries, platforms, gatekeepers of information, And all these vocabularies have meant different things to different people. The platform vocabulary, the gatekeeper vocabulary, the intermediary, the matchmaker, whatever you want to call it. Ultimately, they are capable of searching and sorting through billions of web pages, and they serve only the results which are most relevant to users. And this is their technology, and these algorithms are what make them unique. You can see how difficult a job they have done and how incredible an effort has gone into the product by merely looking at the number of nations and countries that have become upset with the results of the searches, and that have come up with vocabulary that says we're going to find our own search engine. And sovereign nations have found that this is huge engineering, an incredible task, and it's easier said than done. So there is a value to be protected, obviously. These platforms, they do not, however, perform this sorting as a public service. So clearly, they generate revenue from the attention of their users, and this happens mainly through advertising. The recent developments indicate a rising trend of new form of abuse called self-preferencing in the eyes of the antitrust authorities. The gatekeeper, so-called gatekeeper entities or companies are being placed under an opaque obligation to ensure equal access to the rivals of their rivals to their innovations. It is very difficult to determine if this equal access liability is stifling new innovation. Would they have gone into the business of creating the value had they known that they're not going to be able to capture the value? These are all valid discussions. Just because there's a risk there, no one has to be very lenient in antitrust enforcement. Whenever, you know, a speech such as the speech that I am delivering is made, the following speaker, especially if the following speaker is from an antitrust agency, would say, well, yeah, with all these kinds of deferences to the effort that is going in and to the innovations, we have come very close to a point of tipping. So now there is urgency, and we need to cascade this operation. There is no longer the baby steps recommendation that you have been giving us. So test the results of your enforcement, take baby steps and see where that brings you. This is no longer valid. We need to act in a draconian manner, is what some antitrust agencies say. Indeed, the decisions of antitrust agencies in a variety of jurisdictions that find these companies and find new potential probes against these companies. There is one against Google regarding its vacation rental tool. There are probes against Amazon, Apple in the self-preferencing realm, or arguably in the self-preferencing realm. Expedia and TripAdvisor are also under some pressure. All these decisions of antitrust agencies to engage with these counterparts also are informed by the current dynamics, that snapshot of the marketplace. It's very rare to see an antitrust agency looking into the historical development of that marketplace. You know, for example, there's now the local unit issue with Google, which is what allows you to do a search on Google and say hospital, and there's immediately a map that shows the hospitals near you, or a restaurant, and it goes for the restaurants that are near you and all that. You haven't gone for a very lengthy explanation, but there's just that unit that shows it very quickly to you, just in case, you know, are you in need of a hospital immediately? Is something going on? Here's a map. And it wasn't like that before. You were getting the blue links before, and you needed to click and everything. Then the local unit has happened as a way of further serving the customers. Now it is under attention as to whether this is leading to any kind of exclusionary practice. And when antitrust agencies are looking into these kinds of things, they come up with an idea of the marketplace as if this was just devised to gain a competitive advantage, or this was just devised so that some other players can be excluded. And this is obviously not ideal in the antitrust realm, especially when you're doing something in the digital markets. There is room to argue that all of this is stemming from the attempt of antitrust agencies to be innovative themselves. So they're countering innovation with innovation, basically. They're feeling that too much is changing too quickly. We have been enforcing against cement manufacturers and dyestuffs, and the world has changed. We need to equip ourselves with different tools. So let's come up with more fluid vocabulary. Let's be innovative people. But unfortunately, in the field of enforcement and in the field of competition law, this is also taking away a lot of legal certainty. And when you take a toll on legal certainty, this may in turn mean that the kind of dynamic efficiencies that you have been observing may not be observed in the future. So you might end up in a situation where you are actually punishing entities that are taking a leap of faith and are being successful. So what is the big deal with legal certainty? Well, legal certainty is a fundamental principle of the rule of law, first of all. You know, it should be allowing for any entity to operate in a given jurisdiction with some security as to what the effects of its acts and transactions are going to be. So they're going to have legitimate expectations, and law is going to be enforced on them non-retroactively in a foreseeable manner. It is highly doubtful as to whether the heads of the antitrust agencies of today, if they were given the developments in some of these countries as CEOs of those countries, whether they could have said, this is going to lead to an antitrust issue back in the day. So this is a byproduct of the fluidity of the market, the technology intense nature of these markets, and therefore one has to make sure that the legal certainty is being protected by the competition agencies as well. Yet they're very rarely coming up with a decision that says, okay, here is how you could have done it better. I'm siding with you. And that there shouldn't be a talk of administrative monetary fines or anything, because this is all new to all of us. This is not one of those cases where you have willfully entered into a zone of violating antitrust laws. We're breaking new ground here, and we know as the antitrust agencies, so let's side together. This does not seem to be the spirit at the moment. So procedural rules of fairness, of due process, procedural fairness are being left quite frequently by antitrust agencies that believe that these companies are the new devil. We're hearing this more and more from academicians. We're hearing this more and more from competition enforcers of different jurisdictions. But ultimately, adoption to dynamic markets does not mean constantly putting forward new and groundless concepts that can conflict previous precedents and tools. Yet, because we're in the digital market, it seems it's okay to very significantly diverge from previous precedents and tools. Well, it may well be, but in that case, at least these antitrust agencies would need to remember that these products were being brought about under the rules of, say, Oscar Bronner and the like. Whereas now these agencies are using completely new tools, and they're finding themselves innovative in attending these issues, but these issues are newly being articulated. So they need to be molded together with the industry participants, believing in their added value and believing in the virtue of not having them stagnate, not having them in a state of apathy, if you will. Because if you enforce from too many different angles for too many times in an unforeseeable environment, all that fog is basically going to lead to a state of apathy. You know, the story of a hamster that is you know, pushing one button and is getting food all the time, another button and getting sexual stimuli, another button and unpleasant electroshock. The pattern is memorized, and then we always food, sexual stimuli, food, sexual stimuli. Then you start mixing and matching, and there is no algorithm to which the hamster can understand or the dog can understand. So it's just, you know, it doesn't make sense. I do this twice, and for 2 times it was food. Now it's unpleasant electroshock. What's happening? Then the dog or the hamster falls into a state of apathy. You would see that there is no pushing of no button anymore, even if the dog is hungry, even if there are requirements of certain needs and processes. This should not be brought upon the digital markets by way of all these new concepts being thrown, and at the same time them being constantly kept at fault for things that should be seen as breaking new ground. Therefore, the cases that are being brought should be more adequately reviewed under a refusal to supply notion. And once this refusal to supply case notion is used, if the antitrust agencies have felt that these tools are not adequate and therefore they have to come up with new terminology and new principles, then they should at least cut some slack to these entities that are also trying to create value. If the antitrust agencies were to feel that these entities are openly engaging in a wrestling contest with them, they can always punish that kind of behavior anyway. But if you have found 2.4 billion euros at the end of a case that has started in 2010, ended in 2017, such as the Google shopping case, and you have come up with very many very new concepts of competition law and a different idea of allegation, then what would be expected is that you wouldn't do this with administrative monetary fines, and you would be very, very supportive in explaining what the issues are and how these can be avoided, and also listen to the entities in terms of what the market impact of what is being done could be. An example of this is also being seen in Turkey right now, where Google shopping is no more. There's no shopping anymore in Turkey because of antitrust enforcement. Well, because of antitrust enforcement, or because of mismatches between what the antitrust enforcement has expected and what Google said is meaningful and possible and feasible. Ultimately, it is not the competition authority turning off Google shopping, but what I am trying to explain is that these kinds of enforcements can be counterproductive as well if they do not take into account the situation and limitations of the entities or the basic intrinsic meaningfulness of the product. Antitrust agencies should not think that these products are going to be meaningful and there's going to be a virtue in them regardless of how they're squeezed and shaped and reshaped and molded. If you order these products too much around, if you mold them too aggressively, if you demand too many things on them, the business case for them may be lost. The meaning of the consumer experience may be lost. So ultimately, the main issue here should be handled through a refusal to supply analysis. And it should be recognized that the roots of the self-preferencing matters are the refusal to supply cases as well. When certain conditions were not met, antitrust agencies called the activities of certain entities self-preferencing, and the new form of competition law breach was dedicated to these entities. Therefore, just because this is labeled as self-preferencing, proving standards to be applied cannot be ignored, and there has to be the same standards of proof that has been demanded from refusal to supply cases for decades. This type of an abuse is generally not very frequently tested these days under the seminal principles of refusal to supply cases. So basically what I'm trying to say is antitrust agencies are creating micro essential facilities cases almost, and they're not calling it essential facilities cases. If you wanted to test a product or service under the Oscar Bronner test, it could only constitute an essential facility if the access to such product or service is indispensable to offer new products and services. This is not met in most of these cases that we have. There should be no actual or potential substitute for such a bottleneck. The refusal to supply should be likely to eliminate all competition in related markets in which the access seeker will be active. So these kinds of conditions are there, and these kinds of conditions are very frequently seen as indispensable when you are demanding an essential facility holder to share its product. But now that we're characterizing things as gatekeeper activity, self-preferencing, and what have you, suddenly we're not using these kinds of principles, which then has a toll on creating and capturing value. Overall, when the illegality of conduct is not clear ex ante, imposing severe sanctions may run counter to the principle of legal certainty, as I have explained. And then in dynamic markets, undertakings may cease to innovate if they're aware that their success will be sanctioned due to the reason that they're in a dominant position. Thanks again, actually, to their successful innovations. We would not know, not the antitrust agencies wouldn't know, we wouldn't know as the antitrust academicians, and sure enough, the consumers would not know because this would be a sliding doors moment, basically. We would be missing on an opportunity and progress would be with a different kind of a graphical increase. But ultimately, we would not know what has happened because we wouldn't catch the sliding doors moment. That is why antitrust agencies should be using baby steps in their enforcements and should be checking the results of their enforcement. It doesn't mean that they should go weak. It doesn't mean that they should go soft, but they should make sure that they are taking the chances of providing guidance on how the abuse of a dominant position happens in these kinds of dynamic settings. They should strike a better balance between legal certainty, competition, and deterrence without stifling incentives to innovate, and eventually they should foster a creative and competitive environment. They shouldn't assume that this was going to happen anyway, even without the contribution of these kinds of entities, and that these entities are all about taking something and there is no added value that they're bringing. Currently, the trends of enforcement make one think that these balances are not being observed sufficiently, and therefore it is time to rethink. I respectfully contend it is time to rethink whether we should recalibrate antitrust enforcement as one that takes side with these entities rather than always subjecting them to an unforeseeable type of enforcement that throws at them new vocabulary, new positive duties to comply with, and new risk factors. Thank you. I hope I haven't taken too much of your time with this submission. I'm happy to take any questions you might have.
Thank you, Mr. Gürkaynak, for this informative presentation. I see one question in the chat box. Ebru Mertürk asks, could you maybe explain in which way you see differences in enforcement when it comes to the EU and Turkey? Because you mentioned it does no longer exist in Turkey. Is that because enforcement there is further developed or maybe stricter?
The Google Shopping functionality does not exist in Turkey anymore because the Turkish Competition Authority has asked for more than what was seen as compliance by the European Union Commission. This does not in and of itself mean that the Turkish Competition Authority has done something wrong, because it's an independent competition authority, and it's an independent competition authority of a sovereign state. But ultimately, what we need to observe here is that the Turkish Competition Authority has asked, has openly stated that what the EU has seen sufficient is actually not sufficient, and they have asked for more. And when they were asking for more, this came in the form of meddling with the product design. So the request was going so much into the product design that ultimately Google has said this product is not going to bring any reputation or honor or functionality to us. In that fashion, this product is going to just mean that we're going to disappoint anyone who is living in that ecosystem. So it's better to shut it off. So that's what happened.
Thank you. Do we have any other questions? Yeah, I think no. So I have a question.
Sure.
You mentioned about legal certainty. So when it comes to the legal certainty, on one hand side, you have to ensure, you have to set the rules and possible sanctions in order to provide legal certainty. But on the other hand, the digital markets are dynamic and the balances are rapidly changing, so that how do the authorities or regulators may find a balance between providing legal certainty and the capability of giving response to the rapid changes of digital markets?
So this is exactly what competition authorities will have to do. If you were to ask me, how is the legislature going to keep up with this? I would have said they should give room to maneuver to the enforcer. Yet now there is that room to maneuver, and the legislation is not strangulating the enforcers, but the enforcers are acting as if their hands are all tied, and you know, this was a slam dunk type of an enforcement. So for the enforcers, it's not that difficult, really. Whenever they ask for a meeting, the meeting happens. Whenever they want to learn about something, they ask questions and they get the responses. It's not easy for them. I'm not saying their job is easy. All I'm saying is, if they wanted to empathize with the authority, if they wanted to capture a current moment in a space of continuum of time, rather than looking at it as a snapshot, they have the tools to be able to do that. The counterfactual analysis is not unattainable. It's just a matter of whether the authorities want to do it or not. Really very much like the matter of innovative efficiencies in general. Innovative efficiencies, as you may have been observing, they're being used very much by the antitrust agencies whenever they're going to articulate a theory of harm. whenever they're going to be expected to use it as an explanation as to why there is a particular behavior, whenever it's presented to them as a defense, then they label it as soft or incalculable, yeah, innovation, synergies, whatever. But when
I think we are having problems.
As a source of worry, then suddenly you're seeing it as a very articulable matter. So it's a matter of when there's a will, there's a way, kind of a situation. I see Thibault has a question as well.
Yeah, I do, because I agree with many points, and I've been thinking about that for quite some time now, and to me, it's still unclear what to do with it. You mentioned time many times, and I think it's a big issue in the field of enforcement, that we look at things in a way which is very static. Time is almost never taken into account. But that being said, I do have a few suggestions, but I'm not exactly sure how we could transform antitrust by taking time, by putting time at the very center, which means dynamism, right? So I was wondering if you have any concrete suggestions, because of course the issue is always agencies do that because then they could apply a mathematical formula without time, and it's very easy. And then if you say no, it's about dynamism, if you are all soft, then you can't win the argument, because always someone going to come with a mathematical model, and there's nothing you can do. So I was wondering if you thought about that issue, and in a very specific way for the time.
I have, and that's the baby steps broadcast that I am coming up with. So basically, in these kinds of markets where a few things can be recognized by the enforcers, they should take baby steps and test the results. The few things being: one, I do not know this product, how it came about, and where it is going. Even the producers of this product do not exactly know where this product is headed. So there may be a natural evolution of the product, and I might be doing too much, and this might be perverse enforcement. I should be careful. That's why I'm going to test the results of my interferences, and I'm not going to be too draconian. Much like, what would have happened if competition authorities around the world were as aggressive in technology markets and anything new, and calling everything tying and what have you. Would you have had a success by Canon, for example, in bringing a case against iPhone, saying they're tying a camera with a phone? What would have happened if the central locking system of a car, when it was optional back in the day, and you needed to take your car to a specific vendor who had these products, and they would apply a central locking system to your car? A car today has intrinsically the central locking system. And my son, 8 years old, would tell you that he cannot imagine a car without a central locking system. But back in the day, when I was a kid at his age, the right mirror was optional, at least in Turkey. Well, okay, you need to check the left mirror, but do you really need the right mirror? And now a car is a wholly different product. So the point I'm trying to make is, when interfering with product design, when interfering with the natural evolution of a product, the competition authorities should be a little bit more shy. It doesn't mean that they need to go weak. It means that they need to go deeper. And it means that they need to look into the evolution process and take measures accordingly. We know this from the nature. We know this from our daily lives. This is not something new to us. When we go in safari in Serengeti, we do not try to rescue an animal that is being chased by a lion, because we know that we will be breaking the balance of something. That our immediate reaction, immediate fairness understanding, the snapshot of what is happening in front of our eyes may not be all that there is to it. The carcass of that animal is going to be fed on, and then there are going to be microorganisms around and everything. So we just observe, and then we interfere when it is necessary. And we're trying to determine the points in time where it is necessary. This, it seems, is not being done as much by competition authorities when it comes to the digital markets, because the idea that tipping is upon us has taken over. There is a fear factor now, so there is an autopilot driving at the moment, and that autopilot is quite cruel in terms of how it is molding these markets.
Yeah, I mean, if I may just react, this triggers lots of readings that I've done recently regarding Darwin and all of the evolution and how this might be helpful when it comes to competition law. And indeed, this is not done by any agency. Just one thing I wanted to mention is that you mentioned hardware, right? A camera output of an iPhone, which of course is the thing where agencies, they will never want to go for that. And if you look at the DMA and the DSA, they say it's all about services, online services. Yep. Hardware is not part of it. But here's the thing. Let us say I build a car, and for my car, I do need to have something which is a bit digital, right? Which will be the thing where I could turn on the radio and all that. Well, the DMA and the DSA are not saying that you should be exclusively digital as a company to be seen as a gatekeeper. All you need is to be above the threshold and to have some sort of digital activity. So BMW, Renault, Peugeot, all you want, they're all part of the DMA, which is not intended. So although the DMA wanted to exclude hardware, should you do something digital for 0.1% of your activities, you are part of it, which is a nightmare. Because indeed, it means that the camera on top of a new iPhone now is prohibited if it was something new for the future. Yeah, it's a consequence that they probably did not expected when drafted the DMA. I'm curious to see if they will correct that, but we'll see.
Yeah. All right. Oh, there's one last question. I hadn't seen it. So it says, what are your views on reversing the burden of proof to overcome the enforcement problems you talked about? Is it a viable solution? Reversing the burden of proof would suggest that the burden of proof is on the entities defending themselves. Actually, the burden of proof rests on the competition authorities anyway. So it's more than a burden of proof issue, it's a standards of proof issue. What standard of proof should be used, and which precedents should be controlling precedents? I think that's where our answer is going to be.
Thank you. Any more questions? I think so, no?
All right.
So thank you, Mr. Gürkaynak, for your
pleasure.
presentation and contribution. So that's all we have time for. This is the end of our webinar. I think Mr. Capobianco has already left for another meeting. So again, I'd like to thank all the speakers and audience for their participation. I hope that we will be meeting in the next events of the Law and Economic Society in the following weeks. To be updated about our next events, you can follow our social media channels. Have a nice day.